The moment permanent human settlement begins on the Moon, a legal question emerges that Earth has never faced before. What is the status of a human born outside Earth? At present, international space law is built around the Outer Space Treaty of 1967. That treaty establishes that no nation may claim sovereignty over celestial bodies. Space is the province of all humankind, but the treaty was written before anyone imagined permanent cities, multi-generational habitats, or lunar civil institutions. So the real question is this: if a child is born on the Moon, what nationality do they hold? Do they inherit the citizenship of their parents? Do they belong to the sponsoring nation of the habitat? Or do they become the first lunar citizen, independent of Earth sovereignty? This is not philosophical. It is legal architecture. Under current law, jurisdiction in space follows the launching state. If a habitat is built by a consortium registered in one country, that country retains jurisdiction over that structure. But that model collapses once the Moon contains multiple international habitats, private corporate settlements, autonomous economic zones, populations born off Earth. A new classification becomes necessary. Lunar residency is not lunar sovereignty. The Moon must remain non-sovereign territory under international law to prevent geopolitical conflict. But that does not prevent the creation of a structured lunar civil identity. The most stable model would be dual jurisdiction framework. Lunar inhabitants retain Earth citizenship, while simultaneously holding lunar residency status, governed by a multinational lunar charter. This charter would define civil protections, dispute resolution mechanisms, property usage rights, labor standards, resource licensing, environmental obligations. Lunar citizenship, therefore, is not national sovereignty. It is functional governance within a non-sovereign territory. The Moon becomes a chartered civilization zone. This prevents the militarization of identity. It prevents territory claims. It prevents colonial competition. Now consider the deeper structural issue. If the Moon develops a population of millions, or even billions in future centuries, that population will eventually demand representation in decision-making. But representation cannot follow Earth nation-state lines. That would re-import terrestrial conflict into lunar space. Instead, representation must follow operational districts, habitats, industrial sectors, scientific zones, agricultural domes. Representation is functional, not territorial. This is a post-sovereign model, and that is what makes lunar governance unique. The Moon is not an extension of Earth politics. It is the first opportunity in human history to design governance before collapse rather than after. Interplanetary law must therefore establish three foundational principles. 1. Non-appropriation of territory. Equal access through regulated licensing. 3. Civil protection independent of Earth political shifts. If those principles are embedded early, lunar civilization becomes stabilizing rather than destabilizing. If ignored, the Moon becomes the next geopolitical battleground. This is why lunar governance must evolve before mass settlement, not after. The Moon is not merely a destination, it is a constitutional experiment for humanity.